Hey, everybody. The latest news in the ongoing legal saga between, well, technically, Steven Donziger, representing the Ecuadorian plaintiffs, so really it's Steven Donziger and his legal team, and Chevron has taken a new twist that is not in Donziger's favor, and it is that Canadian court has ruled the case that Donziger, the lawsuit that Donziger presented against Chevron in Canada was dismissed, and really for good reason. Now, before you say, okay, Zinni, what is this all about? Let me tell you the whole story and take you back a ways, because I know that people know only bits and pieces of this. This story originates in the 60s, specifically 1967, when a consortium, an oil production consortium called TexPet, or Texaco Ecuador Petroleum, Texaco Petro Ecuador Petroleum, excuse me. Petro Ecuador is the state-run oil company representing the country of Ecuador, was formed and lasted between 1967 and 1992. During that time, Ecuador's share of ownership of TexPet increased to the point that by 1989, it was at approximately 72%, 89%. And to the point where, for all practical purposes, Texaco, not Chevron, Texaco was basically not involved in running the organization. In 1992, the organization was disbanded and all of the assets were turned over to the state of Ecuador and Petro Ecuador. In 1993, Steven Donziger, a plaintiff's lawyer who was active in Ecuador, saw an opportunity to seek environmental justice and filed a lawsuit against Texaco, alleging that Texaco did not clean up its share of the environmental leftovers, if you will, and oil spills that were caused, even though by the time the consortium was turned over to Petro Ecuador, it had caused the oil spills. It was responsible for the environmental damage and was doing nothing to clean it up. So by 2005, the ownership of Texaco changed to Chevron. Chevron inherited the problem. Chevron had no assets at all in Ecuador. And Donziger saw an opportunity because something else happened by 2005 and then 2006. Ecuador turned from being a right-wing government to a left-wing government. However, even though it turned from right-wing to left-wing, it still had this kind of overarching problematic kind of caste system where lower-rung indigenous people were basically got none of the oil spoils, not spills. They got the spills, but not the spoils coming to them. So Donziger saw an opportunity to cozy up to the then new leftist president, Rafael Correa, and by his own admission, Donziger's own admission in the outtakes of the movie Crude, which is supposed to be this kind of heroic stamp on what Donziger was doing, but actually wound up being the seeds of his downfall, said that he had to, adopt the when in Rome idea. That is, when in Rome, do as the Romans do. Or in Donziger's case, bribe judges, falsify information, and bully judges and court and legal representatives. Donziger did everything, including that, and admitted this on camera. And on top of bribing judges and intimidating judges, he ghost wrote. In other words, he wrote his own judgment against Chevron to the tune originally of about $19 billion. Yeah, I said billion, all right? Steven Donziger's behavior was so in your face, so arrogant, so self-assured, and yet so criminal that Donziger himself even predicted that he would become a billionaire from his actions. I kid you not. And all the while, organizations like Amazon Watch partnered with Donziger and arguably aided and abetted the fraud scheme that he had created. Why do I say fraud? Because, first of all, according to, among other things, a 1998 document, a contract that was submitted by Texaco before it was purchased by Chevron to Ecuador and then signed by Ecuador, Ecuador said to Texaco, hey, you've done your $40 million of environmental cleanup, you're free to go. And they were already out of there, okay? They had done their environmental cleanup. But what happened after that was primarily because Ecuador was not putting the right enough resources into environmental cleanup of its own oil production. They were just sort of running at bare bones and just doing it, right? They were causing oil spill after oil spill, essentially hurting their own people. And yet they would blame American companies for their problems. This is so bad. This goes beyond Texaco and Chevron. Occidental Petroleum, for example, was kicked out by Ecuador in 2007, just unceremoniously contract cut, kicked them out by the Rafael Correa regime, and the Ecuadorians stole their luxury cars, okay? This was the worst situation an American company could be involved in, but it was made worse by the fact that an American lawyer had crafted a scheme of lies, hired consultants, and then penciled in what the consultants should say in terms of lying about the environmental damage that wasn't done. Telling people to basically lie on behalf, indigenous people had no idea, forging their signatures, getting their signatures any kind of way they could, and they had, in many cases, no idea what they were doing. It is the picture of a fraudulent scheme to make billions of dollars. When in 2011, Donziger finally convinced his bribes worked, an Ecuadorian court to render a judgment of 19 billion, which was soon thereafter reduced to 9 billion, still a lot of money. Chevron took the problem of what they alleged was a RICO violation to the United States and the Federal District Court in New York under Judge Lapham. Lapham found that Donziger indeed was guilty of the violation was called RICO, Racketeer Influenced Corrupt Organization Act, and said that he could not collect the judgment that he engineered in Ecuador anywhere. But it didn't stop Donziger from challenging that ruling. Donziger was also quite disrespectful and continues to be to this day disrespectful of Lapham on a way that's personal. So Donziger went to Brazil, Argentina, Gibraltar, and the International Tribunal at The Hague, and lost in all of these occasions, trying to get at least one court to say, hey, you know what? That money's yours. And then, of course, he went to Canada. And as of today, Canada said, hey, you know what? You've exhausted every other way to prove, talking to Donziger, way to prove that you've got merit in this case. So this case doesn't even belong in our court anymore. Dismissal granted. To that, Chevron issued this statement. A group of Ecuadorian plaintiffs whose litigation against Chevron Corporation has been exposed as a fraud and bribery scheme by courts in the United States and elsewhere has ended its Canadian lawsuit against the company. Following dismissals of their claims in Argentina and Brazil, findings against them in the United States and Gibraltar, and a ruling at The Hague that the Republic of Ecuador's failure to prevent the continuation of the fraudulent litigation scheme violated international law, the plaintiffs ended their only remaining lawsuit by dismissing the Canadian case. The plaintiffs further agreed to pay costs to Chevron. Chevron had recently moved to dismiss the Canadian suit on the grounds that its continuation would be an abuse of the country's legal system, a waste of its judicial resources, and contrary to international law. The Ecuadorian plaintiffs and their counsel did not oppose Chevron's motion to dismiss and instead consented to the unconditional and final dismissal of the lawsuit. Quote, Chevron is pleased that the promoters of the fraudulent scheme have apparently realized that no legitimate court would enforce the judgment that they purchased in Ecuador. Chevron will continue its efforts to hold the lawyers and investors behind this fraudulent scheme accountable, said R. Hewitt Pate, Chevron's vice president and legal counsel. Because Chevron never operated in Ecuador or had assets there, those seeking to profit from the corrupt Ecuadorian judgment have unsuccessfully attempted to enforce it in Argentina, Brazil, and Canada. Courts in Brazil and Argentina previously rejected enforcement attempts in those countries. With all attempts to date to enforce the Ecuadorian judgment having been defeated by Chevron, the key remaining proceedings in connection with the dispute is Chevron's arbitration against the Republic of Ecuador before an international tribunal in The Hague. The tribunal last August held that the Republic of Ecuador had violated its obligations under international law in issuing the corrupt $9.5 billion judgment. Chevron is currently seeking to recover from the Republic of Ecuador costs it incurred to expose and defend against the fraud perpetrated against it. Also pending are contempt proceedings brought by Chevron in federal court in New York against adjudicated racketeer and suspended lawyer Steven Donziger, I'm still reading the press release, who led the failed efforts to enforce the fraudulent Ecuadorian judgment. Last year, Donziger was suspended from the practice of law after having been found by U.S. federal courts to have violated the Racketeer Influenced and Corrupt Organizations Act, RICO, by engaging in multiple acts of extortion, money laundering, wire fraud, witness tampering, bribery, and obstruction of justice to procure the Ecuadorian judgment. On May 23rd of 2019, Donziger was held in contempt of court for his breach of the RICO judgment, which prevented him from profiting from the fraud by selling interests in the Ecuadorian judgment to investors and using a large portion of the proceeds on personal expenses. The court further ordered Donziger to transfer to Chevron profits traceable to the Ecuadorian judgment. The Canadian decision is the latest in a string of judicial victories for Chevron's worldwide defense against Canada, and the Netherlands ruled in favor of Chevron in related proceedings. On April 4th, the Supreme Court of Canada declined to hear an appeal of a decision that had dismissed all claims seeking to enforce the Ecuadorian judgment against an indirect subsidiary of Chevron in Canada. On April 12th of this year, the Supreme Court of the Netherlands rejected the Republic of Ecuador's attempts to nullify decisions of the International Tribunal in The Hague that ordered Ecuador to take all steps necessary to prevent enforcement of the Ecuadorian judgment against Chevron anywhere in the world. Last August of 2018, the International Tribunal in The Hague also found the Republic of Ecuador liable for violating its obligations under international law. In a unanimous ruling in favor of Chevron, the tribunal, including the arbitrator chosen by the Republic of Ecuador, held that the $9.5 billion judgment rendered against Chevron in Ecuador in 2011 was procured through fraud, bribery, and corruption, and was based on claims that had already been settled and released by the Republic of Ecuador years earlier. The tribunal, after hearing the testimony of numerous experts about the environmental conditions in Ecuador and visiting the former area of operation, rejected Ecuador's environmental allegations against Chevron and Texaco Petroleum, TexPet, as I told you about, which became an indirect subsidiary of Chevron following its acquisition of Texaco in 2001. The tribunal found, and I quote, TexPet spent approximately $40 million in environmental remediation and community development under the 1995 settlement agreement, carried out by, and I quote, a well-known engineering firm specializing in environmental remediation, and that Ecuador in 1998 executed a final release agreement certifying that TexPet had performed all of its obligations under the 1995 settlement agreement. The tribunal found no cogent evidence supporting Ecuador's claim that TexPet failed to comply with the terms of the remediation plan approved by Ecuador. The tribunal concluded that Ecuador's judgment violated international public policy and I quote, should not be recognized or enforced by the courts of other states. The tribunal ordered the Republic of Ecuador to permanently render unenforceable the fraudulent Ecuadorian judgment against Chevron. The tribunal also ordered Ecuador to compensate Chevron for any damages arising from the fraudulent judgment. A process is underway for the tribunal to determine the amount of the damages owed by Ecuador to Chevron. The findings of judicial fraud of the International Tribunal in The Hague are consistent with findings of U.S. courts that the Ecuadorian judgment against Chevron was the product of fraud and racketeering activity, including extortion, money laundering, wire fraud, witness tampering, judicial bribery, Federal Corrupt Practices Act violations, and obstructions of justice. United States federal courts have prohibited enforcement of the Ecuadorian judgment in the United States and ordered the Ecuadorian plaintiffs and their lawyers to pay back Chevron any enforcement proceeds they obtained anywhere in the world. That decision, specifically the RICO judgment, was upheld on appeal and is now final after having been denied review by the United States Supreme Court. As in Canada, the plaintiffs' other attempts to enforce the fraudulent Ecuadorian judgment in jurisdictions around the globe have failed. 1. In November 2017, Brazil's Superior Court of Justice unanimously rejected the attempt to enforce the Ecuador judgment there. Brazil's Deputy Prosecutor General stated the judgment was, and I quote, issued in an irregular manner, especially under deplorable acts of corruption. 2. The Brazilian decision followed a ruling by a court in Argentina in October 2017, which also denied recognition of the Ecuadorian judgment. The Court of Appeals upheld this decision in July of 2018. An appeal is pending before the Supreme Court of that country. In December of 2015, the Supreme Court of Gibraltar issued a judgment against Amazonia Recovery Limited, a Gibraltar-based company set up by the plaintiffs' attorneys and investors to receive and distribute funds resulting from the Ecuadorian judgment, awarding Chevron $28 million in damages. The court also issued a permanent injunction against Amazonia, prohibiting the company from assisting or supporting the case against Chevron in any way. The court issued a similar ruling in May last year, 2018, against the directors of Amazonia, Frente de Defensa de la Amazona, and Ecuadorian attorney Pablo Ferrado for their role in attempting to enforce the fraudulent Ecuadorian judgment, this time awarding $38 million in damages to Chevron. Chevron Corporation is one of the world's leading integrated energy companies. Through its subsidiaries that conduct businesses worldwide, the company is involved in virtually every facet of the energy industry. Chevron explores, produces and transports crude oil and natural gas, refines, markets, and distributes transportation fuels and lubricants, manufactures and sells petrochemicals and additives, generates power, and develops and deploys technologies that enhance business value in every aspect of the company's operations. Chevron is based in San Ramon, California, and more information can be found about this at the Chevron website at chevron.com. Now, you may wonder why I took time to read that entire press release, and I will tell you. Because aside from the details and the outcome, the Chevron Ecuador case has become sort of a kind of a measuring stick for whether you're left or right. Folks, this has nothing to do with left or right, and everything to do with corrupt. And in this, I guess you'd call it era of ecoterrorism, be it physical ecoterrorism or legal ecoterrorism, there have been far too many instances, examples of people, rather than dealing with the truth about something, concocting a falsehood, creating a fantasy, and then around that fantasy accusing people and corporations that they're bad, and having you, or in some cases bullying people like you and myself, into believing their cause is good and just only because they say so, or because they get an actor or an actress who doesn't know any better to say so as well. This has gone on for several decades. This has formed opinions about oil companies that are not just. Just because an organization is big or white or of color doesn't mean that it deserves to be the focus of a fraudulent activity. I repeat, just because a company is big and white or of color doesn't mean that it deserves to be the focus of a fraudulent legal claim. That is true for any person or any small business, any entity around the world. There's still right and wrong. But far too often today, there are people who have what ostensibly appear to be good intentions. When you start looking under the hood, you find that they're not. This is something that goes all the way back for me to grad school, to Berkeley, because at Cal, there's this idea that's driven into your head by your colleagues that, hey, big corporations are bad, particularly if they're operating in the third world. And the people who advance that idea, by and large, were white. And so because you wanted to be part of the group, right, because you didn't want to be outcast, you went along with it. And no, going along with it meant not paying attention to any evidence to the contrary. Then something happens. You grow up, you decide you want to, at least in my case, start looking at all angles of a problem and then building your own models, building your own way of thinking about something. And that's when you find the truth. So what I implore on anyone who's watching this or watches this is never accept any story at face value. Also don't do this, because what I'm about to present to you as a habit occurs far too often, which is why it's a habit. I call it fact cherry picking. Cherry picking information that's disparate to prove a point. For example, last night there was a fellow I'm known for some time, Jeffrey Levin, who says, well, okay, you have 65,000 people, he says, employed in the coal industry, and yet 650,000 employed in the clean energy industry. Well, now, see, you don't know any better, so you think, oh, that means that clean energy is better and coal is dirty and all this other jazz, right? Until you start to really think about it. And the only way you can think about it is to do some research on what, for example, coal is. Coal, in and of itself, does not, I can't just hold it and I crack it and it produces energy, right? No, it's a commodity. It is used along with other commodities and other materials, and it's fashioned in a certain way to create energy. Traditional energy. Okay? Traditional energy. So the real question is, how many jobs are there in clean energy versus traditional energy? And the answer is this: 6.5 million versus 650,000. 6.5 million for traditional energy, 650,000 for what are called clean energy approaches. And I'm not bashing the clean energy approaches, because in every aspect of an avenue that I've looked at, like for example, different areas of traditional energy, they all have programs to reduce their emissions release. And I'll tell you something else too on that more. Even if we get, and hopefully we do, to a point of zero emissions in energy, we would still have a global warming problem. Why? Because in a number of studies have presented this. I'm only quoting what I read. I'm not cherry picking, just quoting what I read. More often than not, when I say to you this, it's going to appear very logical, because it is. We're the problem. In fact, if you take a look at the Green New Deal, if I just type randomly right now, I didn't plan to do this, okay? But if I just go and I type Green New Deal, okay? As I just did in Google. And I get Green New Deal and trying to wipe the Green New Deal that the original Green New Deal that Alexandria Ocasio-Cortez wrote. And when I get to the actual PDF of it, this goes back to February 7th of 2019, okay? And here, this is the way it reads. It's a resolution. It's a 14-page resolution. And when I start to scroll down through this 14-page resolution, if it lets me, it reads as follows. This. It says that the first word of it mentions the United States population, the world population. And it says this, that here, I'm scrolling down to read it, because the text what's going on is the text that I'm trying to find for you. Remember, I didn't plan to do this. Basically, they had it in a system that didn't allow you to scroll down through it, okay? So what I'm going through is, and I do suggest that when you find it, you read it, okay? Down here, and UK references, Green New Deal PDF. How's that? This thing's been contaminated with so much by other people's points of view. Here we go. A scrollable version. Okay, I want you to see this. Okay. Green New Deal. The first line, human activity is the dominant cause of observed climate. I tell you, if there's fewer of us on the planet, that lessens human activity. What happens if you put 2 people in a room and the room's well air conditioned? They're going to be pretty cool. But then what happens if, hey, you put 20 people in and then 50? You get the idea. Okay? So, the point that I'm making here is that there's a lot of a lack of desire to look at the truths behind problems and then ask, how can we fix that problem? Instead, what we have, and I think it's reflected in the history of the Chevron Ecuador lawsuit, is a situation where people want to demonize the other person, sue them, jail them, tell them to shut up. That's the climate that we have, and it's not a desirable alternative to a climate of being able to solve a problem by saying, how can we apply technology to reduce emissions and cool down our planet? That should be, in this tech-oriented environment, the major question of the day, but it's not. And therein lay the problem. All right, subscribe to Zenny62. I'll see you soon, very soon.